Kenya was going through a national examination, and Telegram, the platform, was blocked because of allegations that it will slow down exam cheating. This happened also last year. During the Gen Z protests on 25th of June, from 4 to about, for a period of 5 hours, the internet was also shut down in Kenya, affecting some parts of Burundi and Uganda. And the government, not the government, but one of the larger service providers, Safaricom, claimed that it was an undersea cable that cut, but after 5 hours, that undersea cable was repaired. And it was during the worst protests that we've seen in a long time. And so for many years, we thought that internet shutdowns was not something that Kenyans needed to worry about. But now we find ourselves in the company of India.
There's a lot of jurisprudence which is developing in India.
Yeah.
Because sometimes there are state concerns which need to be acknowledged. So India, due to these unfortunate practices, has developed a body of jurisprudence where our judicial branch has instilled some forms of accountability. I'm happy to share notes or to share that precedent, those judicial decisions. And it's unfortunate to hear about this, but it also shows that society in some way is in a flux. I think internet shutdowns are a representative sometimes of a gap between people and the government, which can be bridged through better communication. I think so. That there needs to be emphasis on, rather than shutting out the voices of people, to hearing them and then building trust.
So thank you very much. We'll really benefit from that precedence. Thank you. Yeah, so digital tools are quite vital in terms of citizen participation, especially on economic justice issues. And looking at what happened in Kenya in June and July, it speaks for itself that the online space, the digital infrastructure, that ironically was set up by the government itself. You know, the fiber optic coverage in Kenya is better than most countries in the region, in the Eastern African region, which has also translated into a very tech-savvy young population that use the internet for so many things, including some things that maybe not very good. For example, there was a study that showed that Kenyans were doing research for American and British students for PhD and master's level, which is cheating, right? But this is something that they are doing, and it's a way of living for many people in Kenya. However, there are things to learn from, for example, what happened in June. So if you look at the tools that the government used to perhaps silence critics or to just block the space, was number one was that shutdown. I'll call it alleged now until it is established that it was really a shutdown. But the other one was the use of the Computer Misuse and Cybercrimes Act, specifically sections 22 and 23. Section 22 speaks to publishing false information. Section 23 is publishing false information about a person, so that it's sort of something similar to criminal defamation. Ironically, the Cybercrimes Act came into force in 2018, and the courts, the High Court at that time, had struck down criminal defamation the same year. And so the same year when criminal defamation was struck down, a similar provision was brought back by Parliament. And I don't know whether you can remember, this was the time that there was an allegation by a female, there was a story about female MPs and a certain young man. And if you look at the Hansard, the MPs had said that they will show these bloggers that they cannot really talk about us the way they want. And if you assess who has been arrested under this law, it's usually people who speak truth to power, and the recipient, the person who's allegedly complaining is a person in government or a person who can be said to be powerful. So recently, even someone posted a photo of a casket and alluded that it was someone powerful in the country. That person was arrested and charged under this law. Funnily, no one has ever been convicted under this law. Mutemi Okiyama, in 2020, published a public warning to IMF saying that no one should loan our former president any money. He is persona non grata, arrested under this same provision. And so you find that there are laws within our statute books that are really stifling the space where actually people engage with governance issues. If you follow certain platforms in Kenya right now, Twitter, for example, Kenyans are looking at public documents and translating it into, and actually visiting the ground, visiting where the purported public projects were done, and they find that the project was never completed or never even started. This is digital tools being used to demonstrate how the country is being pillaged in real time. And also, I see another issue with the Cybercrimes Act, those two sections, is that it turns the government into the arbiter of truth. You know, we all have freedom of expression, but there's nothing in the Constitution of Kenya, for example. Article 33 gives us the right to seek, receive, and impart information and ideas, regardless of frontiers, and in any medium. But also proceeds to say that freedom of expression does not extend to propaganda for war, incitement to violence, vilification of others, hate speech. And also says that while exercising freedom of expression, you need to respect others' privacy and reputation. Nowhere in that provision has it said that freedom of expression does not extend to lies. And, it doesn't say that. And we have precedents in Kenya, especially since 2014, coming up to now, that has really upheld freedom of expression. And through this process, and these are cases that I was personally involved in, criminal defamation was struck down because the court said that the prospect of a journalist, for example, being arrested, having to look for a lawyer, having the prospect of looking for bail and bond, and then may actually be imprisoned for writing something about someone else is disproportionate. Then there was Section 132 of the Penal Code, which creates the offense of undermining authority of a public officer. This case was brought about when Robert Alai spoke about something the then president Uhuru Kenyatta said about Raila Odinga. And Justice Mwita said that this is preposterous because you need to be able to talk about the people who lead you. And then there was one called misuse of a licensed telecommunication device, which basically said that you can be imprisoned for up to 2 years for using a device to send a message that causes anxiety to someone else. And that was struck down basically because the court said that anxiety is not, it's very subjective. And for you to limit any fundamental right, that limitation must be written in law, must be necessary and proportionate, and must pursue legitimate aim. And so when we talk about internet shutdowns, is it proportionate when you close Telegram for everyone because there may be students cheating somewhere? Is that proportionate? So these are some of the discussions that we are having.
Thank you, Demas, for highlighting, the importance of safeguarding digital rights to protect freedom of expression.
When we talk about AI, sometimes the biggest concern is that it's a very technical field. And so when you talk about, for example, the AI may produce bias, um, perhaps you need to explain that a little more. And let me give facial recognition as an example. So most AI systems rely on training data. So for example, facial recognition relies on recognizable points on faces. And so you train it using real faces initially. And so what happened is that it was realized, for example, in systems, in facial recognition systems in the global north mostly, especially in the West, that black people's faces were either not recognized as faces or misrecognized, right? So there was an error. Simply because the people who trained this data and the faces that was used to train them were white faces. Yeah? And so that's a source of bias. Another source of bias may also be cultural, because things work in an X way. So as you're training that data, that is how you assume things would flow. But in a different context, that would not be true. Yet, we are using AI to make very important decisions, including on whether you qualify for social services. In other countries right now, your bail and bond is determined by an AI system. And so if that AI has biases cooked into that, then you see it just reproduces injustice. Another issue with AI is that something called the black box, which means that, and this is because AI uses a lot of programs on top of other programs and hardware from different areas. And so sometimes you can feed an AI system with a decision, with data for it to make a decision, but when it makes that decision, there's no way of knowing how it made that decision. So it's almost like a god, where, yeah, you know, and that's called the black box. And till now, no one knows how to solve that issue of the black box. With regard to digital public infrastructure, ICJ currently is involved in a litigation against Tools for Humanity. I don't know whether you remember the WorldCoin issue of certain people who descended in Kenya, but they were rolling this globally, and they scan your iris. So it was a digital ID based on your biometric data, your iris. Then it uses blockchain technology to give you a cryptocurrency account. And then in Kenya, they also would deposit $55. So by the time we noticed, about 300,000 Kenyans had already given their data. And this was before a data protection analysis has been done, a human rights analysis has been done. And so as we roll out these digital public infrastructures, I think it's important for us to really do assessments, and the courts have been very pivotal in setting standards and actually safeguarding Kenyans' rights. So you remember in Huduma number, the first iteration, the court said we need a data protection framework. Then the second iteration came and the court said we need a data protection impact assessment. And as we continue, we're building law and ensuring that Kenyans' rights are safeguarded in this digital age. Thank you.